So a very warm welcome to all of you that are joining us this afternoon for our webinar, Responding to EHCP Consultations. We're presenting today, myself, Nicola Tame. I'm an associate at VWV, and I'm presenting along with my colleague, Bradley Evans, who is a solicitor. We are both in the regulatory compliance team, and we are experienced in advising on the regulatory requirements that apply to all schools. And much of our work is around parent and pupil matters, including special educational needs, equality and behaviour. The next slide, please. So for our EHCP webinar this afternoon and responding to EHCP consultations, our agenda, as we've sent out already, is going to be looking at the legislative framework relating to pupils with SEN and disability, some case law, established case law and developments, preparing a response to an EHCP consultation, considerations for schools when named in section I, education other than at school, management of EHCP placements at risk of breakdown, and also we'll be letting you know how we can help. Hopefully we'll have some time for answering some of your questions at the end. The next slide, please. So just a very brief background in terms of the current landscape for SEND in England. I'm very pleased to see lots of SENCOs on our webinar today. So I'm sure you're very well aware of the current landscape. Just as one of the statistics that I think highlights the issues that are facing schools today is that in terms of the number of EHCPs that are currently in place, we now have, and these are from the government statistics, 517,049 pupils in schools as at January in 2023. And you can see that this is up substantially from the figure in January 2001. And I'm sure most of you won't be surprised to hear that. So demand and need continue to increase, and we have had recently the SEN Green Paper. However, there is now potential political uncertainty due to the upcoming general election. And there's also an area of uncertainty in relation to the safety valve agreements that you may have been hearing about because there's been some media coverage of that. So just to give you a very brief outline of that and how they're relevant is that safety valve agreements were launched in 2021. They're usually an agreement over 5 financial years between a local authority and central government, and they effectively allow a local authority to receive extra funding in exchange for reducing their debts and managing high needs. And there are often terms specific to each local authority. So what that often means is that the local authority concerned who has one of these agreements are looking at reducing high needs fundings, and that may affect you as schools and some of your pupils. There are currently around about 38 safety valve agreements, and so we recommend that you check in relation to your school and your local authority whether your local authority has a safety agreement in place, a safety valve agreement in place, how long it will last, the specific terms of the agreement, and the impact in the local area on placements and placement funding. And you can go on to the government website to check that. So in amongst all of this, what are the issues arising for schools? So what we have seen is that due to the increased numbers of EHCPs, there's inevitably pressure on all parts of the system, and there are increasing numbers of parents taking local authorities to appeal at the first tier tribunal. There are potentially increased strained relationships between local authorities and schools, potentially increased appetite for schools to push back in some way against this. And there can be challenges for staff in terms of, or SLT, in terms of the number of staff available to support pupils. And we often see this as a potential area of parental complaint for schools to deal with too. So we hope we can address the legal understanding and underpinning of the system and give you a better understanding of that, and also give you lots of practical tips and takeaways from our presentation today. Thank you. I'm going to hand over to my colleague Bradley now. Next slide, please.
Thanks very much, Nicola, and good afternoon, everybody. It's great to see so many people attending. Excuse me. Before we get on to the consultation process itself, we thought it would be useful just to briefly outline the main legal framework that sits behind everything we're going to be discussing in this afternoon session. It's a complex area of law, and there's two statutory regimes which apply. They are distinct, but they do have dual duties too, which adds another layer of complication and challenge. You'll also see on the slide there's some abbreviations. Me and Nicola will be using those throughout this afternoon session. So looking firstly at the statutory regime which relates to pupils with SEN, the primary legislation is the Children and Families Act 2014. This is supplemented by the secondary regulations, which is the SEN and Disability Regulations 2014, alongside the SEND Code of Practice, which is statutory guidance. The CFAs specifically reference the Code of Practice, and you must have regard and ensure that you identify and correctly apply the relevant provisions unless you have clear reasons for not doing so. Secondly, looking at the statutory regimes which relate to pupils with a disability, this is slightly more broad and is found in the Equality Act 2010. There's two, I suppose, real key issues we're looking for here. Firstly, it's avoiding discrimination, and secondly, it's the application of and appropriability of reasonable adjustments. Both the SEN statutory regimes and the Equality Act are broad, and there is a complicated interplay between them both, in that sometimes one will apply, sometimes both, and hopefully this afternoon we will be able just to talk through how they work and how best to manage these and get the best result. Lastly, there is case law, which we will be referring to. Please be, I suppose it's a health warning on behalf of us. Some of this may refer to the old regime and the old legislation, which is found in the Education Act 1996, and there may be some old terminology used, such as statements. Next slide, please. Thank you. Carrying on from looking at the main legal framework, there's also a duty to support pupils with medical conditions set out as Section 100 of the CFA. The key point from this slide really is that if there is EHCP provision made, then it is very likely that the school will meet this duty also. Alongside this, you need to consider whether the pupil or student meets the statutory definition of having a disability. And if so, the Equality Act duties will apply, including the need to make reasonable adjustments, which is a proactive duty. Next slide, please. So alongside those, we need to also consider the remedies which are open to schools. Broadly, there are three key ones. There's the statutory regime relating to local authority complaints. That can be found in the Education Act 1996. Secondly, you've got judicial review. Judicial review is a common law remedy and it's very much the nuclear option. There's pros and cons to using it, but there's I suppose you could do an whole webinar on judicial review, but there's certain reasons why you would choose to elect to use it. In very, very broad terms, these are related to decisions of public bodies, including schools, trusts, and local authorities, ensuring that decisions reached are lawful, rational, reasonable, fair, and proportionate. Again, this is a complex area. Finally, case law, and we'll explore these three in further detail throughout the session. Next slide, please. So moving on to the EHCP consultation process. I don't think it would be a lawyer's webinar or seminar without some form of qualification or assumptions. So for the purpose of this slide, we have assumed that the local authority have conducted a statutory assessment and special education provision is required in accordance with an EHCP. Sections 37 to 50 are really the nuts and bolts and which are going to apply to the EHCP process. There's three key sections we're looking at. Section B, which sets out the specific details of the SEN. Section F, which sets out the specific provisions which will need to be required. And Section I will be the section where the name of the school is listed which can be attended, or if a school is unnamed, the type of school that's required to deliver that provision. Sections B and F are prior considerations to the placement at Section I. You'll see on the slide we've referenced Section 38 of CFA. This considers the parental right to request the local authority name a particular school. Excuse me. What does that mean in practice? The law in this area really does favour parental preference, and that's a really key consideration to remember when you're looking at your responses to the consultation process and how you approach matters generally. Next slide, please. So looking at the requirements of the consultation process, there's broadly two scenarios we would consider. Section 39, which is where you're finalising the EHCP and there's a request for a particular school. Alternatively, Section 40, where again you're finalising the EHCP, but there's no request for a particular school. Similarities in both approaches means that in both, the local authority must consult with the school before finalising any plan, and there is a legal test which is applicable to the school's response. I'll run through that in the next slide, but that is a really important point to flag and something that me and Nicola will be honing in on. With regards to your reply, there are 15 calendar days to reply, not school days. It's an important distinction to make. And then upon receipt of your reply, the Code of Practice requires the local authority to very carefully consider your comments in response. Next slide, please. So as I said in the previous slide, the legal test for when responding to the consultation is really fundamental. Nicola and I briefly spoke beforehand, and if there's, whilst of course we want you to take lots of information from today's webinar, we are mindful that we're going to be covering a lot. And if there's 3 or 4 golden nuggets that you are taking from this afternoon, this definitely needs to be one of them. So when you are responding to consultations, this is the legal test of which your response must apply against, and your evidence and how you present it needs to address this legal test. Just take a little bit of time to run through it just to make sure it's clear. So Section 4 will set out where the naming won't apply, and if you're not to be named, 4A states the school or other institution requested is unsuitable for the age, ability, aptitude, or special education need of the child or young person concerned, or the attendance of the child or young person at the requested school or other institution would be incompatible with the provision of efficient education for others or the efficient use of resources. When you are preparing your responses, and we will go through this in more detail in terms of how to present this in a logical way, these are the phrases and this is the area of legislation you need to consider, and your evidence really needs to address this legal test. I'm now going to hand back over to Nicola.
Thank you, Bradley. The next slide, please. So following on from the legislative background that's been set out by Bradley, I'm going to take a look at some case law in the area, and most of the case law is around that statutory test and wording that Bradley has just set out to you. As Bradley said earlier, there is the Education Act 1996 old regime where similar wording was in place, but essentially the current case law is around that very important section that's most pertinent to our webinar today. So Case law is a complex concept. It's essentially largely judicial decisions that assist in explaining the legislation that create precedent and legal principles, but it's often very fact specific, and it's also a body of what's called common law as well, which again is quite complicated. However, I'm going to run through two established cases, which I think are important to consider, and then also some recent case law, and to update you on some important developments within the last year. So the case that I'm going to talk about now is NA and Barnet London Borough Council. You can see it's a 2010 case, so that is under the old 1996 regime. It's an upper tribunal case, which means that it's above the first tier tribunal, so it's a higher legal authority. And this was in the context of an appeal by a parent rather than any action that was brought by a school. And the decision in that case was all about expanding and explaining the meaning of what is effectively now Section 39B(1) of the Children and Families Act 2014. In that case, the school was oversubscribed, and so there was a debate around the legal meaning of what it meant for in the statute for the meaning of children with whom children with whom that child would be educated, i.e. that pupil with the EHCP, and also what efficient education meant. The court decided that both aspects of that test were quite sophisticated, and in terms of expanding upon the meaning of that, they said it depended on the circumstances, but essentially what other children meant was that it was a category of those with whom the child would be educated. So, for example, you may consider that when you're drafting an EHCP consultation response, and we're coming on to that later, that case is essentially saying you need to consider what other children may be affected by this pupil joining, for example, their class. Efficient education, the court decided, indicated a standard of education that was not the very highest standard desirable or the very basic minimum. So it was something in between, and that would depend on the facts and circumstances of the case. They did say that the overall context of the school would be relevant in some cases, especially in relation to whether other adjustments could be made. But that makes it very clear that a specific argument in the EHCP consultation response regarding a particular child in a particular class is what is envisaged within this legal test. The next slide, please. So the second example of an established case is the Medway Council case from 2019. So this is under the current statutory regime, although this is an example of a challenge by an Academy trust to a local authority by way of judicial review. So in this case, the pupil concerned, the pupil that had the EHCP, moved from one local authority area to another. The pupil had an EHCP when they were in the original local authority area, and there were no other changes in the circumstances or needs of the pupil when they made that relocation or move. When they did move, the receiving local authority, so that was Medway, removed large parts of the provision for that pupil in Section F, even though the needs in Section B hadn't changed. And the Academy Trust challenged the local authority on that. The relevant points for the of the decision are that the court decided the local authority, Medway, had acted unlawfully when finalising the EHCP for this pupil who had ASD by removing, without any changes to the evidence or needs, parts of Section F for that pupil, which addressed his special educational provision. And therefore, the local authority had acted unlawfully in that way, and they had also, secondly, failed to engage with the Academy Trust in proper consultation and to give conscientious consideration to the school's response. So in terms of that case, that's important in demonstrating, as Bradley set out earlier, that when an EHCP is drafted, Section B it is really derivative of sections F and I, and one follows the other. The child's needs are set out, then provision is set out, and then after that, the local authority needs to look for a suitable placement in section I, taking into account parental preference, of course. There were also arguments in that case about which judicial remedy or legal recourse or route would be the first to take in this case by an Academy Trust, and there was some discussion around that we'll come to later. The next slide, please. So to come on to the recent developments, and all of these cases on this slide are cases from around about the last year or so. There are two cases about placement and two, the last two I'll skip over a little bit more briefly, are about human rights, because that's also another area of law that's relevant when we're talking about children with special educational needs. So for the first case, that's OO and Bexley, London Borough Council, this really reiterated the correct test under section 39 4B1 that I've described in the Barnett case. And so this is really helpful because it brings the case law under the current legislative framework. And what that case decided is that the test under section 39 is a sophisticated test, and it requires a degree of precision and a careful consideration of the evidence and the detail about, firstly, when you're looking at efficient education of others, firstly, it needs to be considered which other children would be affected by the child in question attending the school. Secondly, what the standard of those other children's education was currently at, whether it was at or above the efficient education standard. Thirdly, what effect the pupil in question's attendance would have on the standards of those other children's education. And fourthly, if the effect was to reduce the standard of the other children's education below that of efficient education, then what could be reasonably done, what adjustments could be put in place, if any, to avoid that effect. So the significance of this case, and this key takeaway from OO and Bexley, is that a broad brush approach to section 39 and the evidence that you're presenting as a school in response to a consultation is not sufficient. And so I'll come to that a little bit later when we're looking at, well, what do we need to do then when we're responding effectively to an EHCP consultation? In terms of the second case there, I'm going to come on to that in more detail in a moment. But to turn to the two cases on human rights, these cases really emphasize that children have a right to education, and this can be relevant in the context of SEN and disability. And also in the first case, Bulgaria case, the court recognised that there's a difficult balancing act for schools when you're looking at a specific child's needs and those of all of their classmates. So those two last cases there are by way of reference. So to come on to the Swalcliffe case, the next slide, please. So the Swalcliffe Park School and Wokingham Borough Council case is around about a year old. And in our view, this is the most important recent case. And there are some key takeaways from this webinar that come from this case. The context is something that you will probably mostly relate to, in terms of this was a pupil with ASD. There was an original consultation from the local authority to the school. The school in this case was a special school. There was an appeal to the first tier tribunal, the SENDIST, by the parent against various sections of the EHCP, including sections B, F and I. And unfortunately, at present, there is a backlog in the tribunals. And so there were ongoing discussions between the local authority, the family and the school, whilst they were waiting for this case to become before the tribunal. And so just before the final hearing of this case, a decision was made at, inverted commas, the door of the court for the section I placement to be agreed. However, this agreement, because the parties to the appeal were the parents and the local authority, this agreement was made between the parents and the local authority, despite the school's objections. And so the school in this case made an application for a judicial review of the local authorities' decisions, and also an application for judicial review of the decision by the tribunal. In this case, the chronology included a residential assessment of the pupil by the school. So therefore they had their own evidence, if you like, in relation to the pupil's needs. There were 3 claims by the school against the local authority and the tribunal. They only succeeded on one ground, and so this case was all about that ground really, and how we can use it in terms of how we respond to EHCP consultations. And that was about what comprised conscientious consideration. And the court referred to the code of practice in the judgment, and also to an established case called gunning and the gunning principles around that. And so the key takeaways from this case is that when there's a consultation, the standards required do need to be in line with the gunning principles. And the 2, I think, most outstanding principles for you to take away from today are principle 2 of those, which is that the proposer, so in this case the local authority who is proposing a consultation, must give sufficient reasons for any proposal to permit intelligent consideration and response. So what does that mean? It means that for a school, you need to ensure that you have sufficient information at the start and during the EHCP consultation process in order for you to respond effectively to the consultation. And what you may recognise is that because this happened over a long period of time, that sometimes the EHCP consultation process can be over a period of time and dynamic, even though you have a statutory window to respond to that initial consultation. And so therefore new reports might be needed, because they may need to reflect a pupil's changing needs, and you need to know that and to base your responses upon that. So the first principle to take away is that you, when you're responding to an EHCP consultation, you need sufficient information to be able to make that response. The other principle under gunning, principle 4, is that the product of the consultation must be conscientiously taken into account in finalising the proposal. So that means that the local authority needs to conscientiously take into account your response, and they need to be able to demonstrate that. The court didn't go so far as to say that the local authority needs to give reasons as to whether it agrees or disagrees in terms of which educational provision is eventually named in section I. However, it referred to the code of practice at paragraph 9.80, and it set out there that the local authority needs to consider the school's response, in inverted commas, very carefully. So what that case decided was that consultation is a process of dialogue and proactive engagement. And in that case, in the Swellcliffe case, it didn't happen. And therefore, the court quashed the decision of the local authority and sent it back for the EHCP consultation process to start all over again. The other interesting fact about this case is that the school did not admit the pupil pending the outcome of the proceedings. So whilst the case was ongoing in the court, the pupil was not admitted to the school. We would put a big health warning here in terms of the possible risks of this type of approach. However, it's interesting to say that the court didn't specifically criticise the school for taking that approach. However, when I come to explain a little bit later some of the routes that are available to schools when challenging, when you have been named in section I, there is a duty to admit, and so not to admit the pupil at that stage needs to be given very careful consideration and legal advice taken. The next slide, please. So that was a summary of the case law and in particular Swellcliffe, which I've put the reference there for you so that you can go and have a look at that, because that's an important decision. How does that apply practically? What does that mean for you? What do all these cases mean for you in terms of how to prepare an effective EHCP consultation response? So I've made quite a list here so that you have them for your reference. So the legal test that you need to apply your reasons, consultation response and evidence to is section 39, as read out by Bradley, and it's there earlier in the slides for your reference. And this is the most important aspect to address. You need to ensure that you comply with the timeline, of course, of the 15 days. And you need to make sure that you look very carefully at the EHCP in terms of what the needs and provision is set out, and to analyse that carefully. Preparation is key here, and I appreciate that all schools are working under time constraints. But if you get the consultation response right at the outset, then this will not only be a key piece of evidence if the school wants to challenge the local authority at a later date, potentially, but also it will be the most effective way of providing the local authority with a robust response. So do your preparation. We are of the view that you're not necessarily restricted to the pack of information and documents that the local authority provides, especially if this is inadequate. So do go back to the local authority if you need further information to be able to give your consultation response. So also be proactive, as the case of Swellcliffe indicates. The initial response is important, and that needs to be within 15 calendar days. But do keep going back to the local authority with evidence and reasons, because consultation is a process of dialogue and proactive engagement. We are able to assist you with drafting responses, and we can assist at that stage, and have been successful in doing that where local authorities have then gone elsewhere. The next slide, please. So the next part is really in terms of how to prepare your consultation response, and what the case law that we've heard about tells us what we need to do. So the representations that you make in your consultation response need to be addressing the legal criteria and as detailed and comprehensive as possible in relation to the individual facts of that pupil and that case. So who are the other pupils that may be affected? What are the individual needs of that particular pupil? Is there anything specific to the school's buildings, the way the classes are set up? What's the risk assessment around this pupil joining the school? So really drill down into the detail, and we would suggest that all of the limbs in section 39 are addressed if it's relevant to the case. Don't just leave it on one limb that you replied to your consultation response. Some of the evidence that we suggest you include are, as I've said, risk assessments, documents that you have, relevant extracts from those, meeting minutes, and also photographs and examples of events, and also, very importantly, specific costings if you're looking at running an argument under limb 2. The next slide, please. So just some more practical tips from our experience, really, is that we have often seen a local authority providing its own form for a school to make its consultation response. It is not a requirement to use those forms, and sometimes the headings that are set out there don't lend themselves to schools addressing the legal tests that we've been talking about today. So it's not a requirement to use them. If there are relevant and correct parts to fill out, then please do complete it, but don't be restricted by that. It's always open to you to add additional evidence and pages of representations if required, because that can be problematic if you don't set your case out fully. Finally, I think we've been through all of the points there. We do recommend that the SENCO is appropriately trained in the statutory consultation process, which is why it's great to see so many SENCOs on the webinar today. And that includes how to complete the consultation response and how to communicate with parents before, during, and after this process, because we have seen examples of parental complaints where this isn't done correctly. The next slide, please. So once you have been named in section I, what are your legal duties? What's the legal position? And this can be most difficult when the school doesn't think it can meet the needs of the child. Now, you are absolutely in a better place if the consultation response was robust. It's a springboard for any challenge on the next steps. So it doesn't mean that all is necessarily lost if you've made a full response and you've put lots of time into looking at that case and the local authority names you anyway. However, a big health warning that under section 34 of the Children and Families Act, schools that are named in an EHCP in section I have a duty to admit that pupil once it's named. So the local authority has the final decision on the naming in section I. And also, once you have the duty to admit, a school also has to make its best endeavours to provide the provision in the EHCP. You will remember I gave this caveat in the Swellcliffe case explanation, but also in relation to the significant risks there is a risk of a breach of statutory duty or a disability discrimination claim, judicial review or parental complaint if the legal duty under section 43 is not complied with. However, it is interesting to note that in the Swellcliffe case, the school did not admit the pupil, and we suggest that you take legal advice if there is a similar situation that you face. The next slide, please. So what can you do where you believe you've been named in section I, but you can't meet the needs of the child? Well, unlike parents, under the statutory regime of the Children and Families Act, there is no right of appeal for a school to the SEN tribunal, and that makes things quite tricky for schools. So if parents disagree with section I, they can go to the first tier tribunal. However, in relation to what a school can do, there are potentially three things that you need to consider. In the immediate term, you need to consider section 43 and the duty to admit. However, we do suggest you consider the individual facts. It may not be necessary to admit the pupil straight away. You may need to request further information from the local authority in order to plan how you are going to admit and support that pupil if you don't think that you can meet their needs. If you do this and take this approach, any delay would need to be for the very shortest time possible. And we recommend that this is communicated with the local authority and parent in order to be clear what the school is doing. We'll then now be talking about the two more legal routes that you may be able to take, and those are sections 495 and 496 of the Education Act 1996, and also judicial review. So the next slide, please. So the legal avenues that may be available are, firstly, so this is the first potential legal avenue, is under the Education Act 1996, and these are general powers that are available. So in amongst all of this, it's important to navigate an ongoing relationship with the local authority, but under section 495, there is a power given to the Secretary of State for Education to determine disputes between a local authority and a school. And under section 496, the Secretary of State for Education can make directions to the local authority where the local authority have or are proposing to act unreasonably. And it's under that latter provision that you could take legal advice as to whether you consider, once you have made a robust consultation response, is the local authority acting or proposing to act unreasonably in going ahead to name the school under section in section I, despite the response that the school has given. Now, we suggest that in terms of pursuing this as a legal remedy, it's a high bar to meet to show that the local authority are proposing or acting unreasonably. And so therefore, you need to choose a case, if you decide to take a challenge upon these lines, very carefully, where you have the best evidence and best consultation response in order to provide some robust challenge to the local authority. So this is, of course, subject to receiving legal advice on this being an appropriate avenue. The next slide, please. We've really been through all of these points in terms of the legislative background to this. So I'm going to go straight on to the next slide, please. So this is the second legal avenue that schools, when named in section I, may wish to consider, and this is the judicial review route of challenge. This is what was used by the school in the Swellcliffe case, and my colleague Bradley has already set out some of the challenges and particularities of a challenge through judicial review. So it's similar to the section 495-496 test in terms of often we will be looking at whether local authority has acted reasonably and within those principles of public law as previously outlined. It's an application to the administrative court and not the Secretary of State for Education, and it's based in case law and is not a statutory route. So the grounds would be that the local authority, in going on to name a school in Section I, have contravened those principles of public law and in some way have acted in a way that's not lawful, rational, reasonable, fair or proportionate. And you'll have seen in the Swellcliffe case that the reasonableness around that was in relation to the process of consultation. There are some caveats there in terms of how challenging it can be to pursue this legal course of action, and it needs to be conducted with legal advice before taking any action in terms of judicial review against a local authority. So those are the two legal avenues to consider, and so we'll go on to the next slide, please. And I'm going to hand over to my colleague Bradley now.
Yes, so we thought it may be useful now to quickly run through illustrative a case study just to cover the last couple of slides that Nicola has helpfully gone through, and just have a quick discussion as to the key points and key avenues that we need to consider. So I'll quickly run through this case study. So an academy is consulted by the local authority in June 2022 to be named in Section I for a pupil with a profound and multiple learning difficulties in the area of cognition and learning. The Academy has an SRP for pupils with mild or moderate learning difficulties, and the consultation response states the Academy cannot meet need. The parent has made an appeal, and there was no further communications at the time. Subsequently, in February 2024, the Academy was notified that it was named in Section I. It's this type of scenario that we're seeing more and more frequently. And Nicola, in your opinion, what would you say the sort of immediate considerations are that the school needs to take into account when it's named in these circumstances?
Thank you, Bradley. Yes, so it's really important for the school to immediately consider, first of all, what was the basis and the content that the school gave in terms of its consultation response, how much detail was there, and how was it evidenced, and also whether the response was made in time.
Okay, that's great. And with regards to the failures in correspondence and the general delay, is that an important point? And how would you sort of go about addressing that?
Yes, it is an important point. And I think Swellcliffe demonstrates the importance of that in terms of how impactful that can be on the consultation process. So it's really important to keep a clear evidence trail of all of the communications between the local authority and the school, and also for the school to be proactive in its correspondence with the local authority, as I outlined earlier. So yes, it is important, and the school will need to address it by looking at what was said.
Okay, and to what extent would you say that perhaps new reports or assessments would be important, and the extent to which schools need to sort of address that and check if there are any in existence?
I think this is quite pertinent, really, because in these situations, unfortunately for schools involved, for everybody involved, this process can drag out over quite a long period of time, particularly if there's an appeal to the first tier tribunal. So what that means is that a pupil's needs may change over time, and as the needs are the driver really of the rest of the EHCP, it's really important for the school to know if there have been any updated assessments or a change in need, in order for it then to address those changes itself in terms of whether it can or can't meet need, and how it responds under Section 39 as a result.
That's great. And I suppose, to what extent, if at all, do you think the school should consider where the child has been educated in the meantime, and how important should that point be in the terms of the wider concerns?
Yeah, there can be times where the pupil may be in a very it may be in a very challenging situation, because the pupil might not be in school at all. The pupil, and we need to take that into consideration in terms of being named in Section I. The pupil still has an ongoing right to education. So I think it's very important to consider what the current educational provision the child has received is, and what could be, potentially put in place.
Brilliant. And my last question, and it's probably quite an unfair question, so apologies in advance, but at a very high level, what legal challenges would you suggest the school considered it would consider to follow in these circumstances?
Yes, so I mean, obviously this is an illustrative case study for the purposes of our webinar. So this wouldn't constitute legal advice on these circumstances. And I think that's the one thing that we need to keep coming back to, is the individual facts and circumstances of any case are going to be most relevant and most important. So in amongst all of that, then the two potential legal remedies that may be open here are either under Section 496 and 495 of the Education Act, in terms of making representations to the Secretary of State, and or, because there's an important question when those two routes are considered, should they be done one before the other or at the same time? And that depends on the circumstances. Also, potentially an application for judicial review of the local authority's decision, in terms of those consultation points that we've seen in Swellcliffe.
That's brilliant. And if we could just go to the next slide, please. We've just outlined a couple of bullet points, which I hope will assist in the key areas that we think are important with regards to that case study, and key things you'd be looking for, and areas you'd be looking to question and challenge if this scenario did arise. So I'll leave that on for a couple of seconds just so you get a chance to have a read.
Yeah, I think I'm just going to draw everyone's attention to the bit at the bottom, really, in terms of that question around the admission of the pupil once
of course.
they've been named in Section I.
I'll hand over to you, Nicola.
Thank you. The next slide, please. So considerations for schools on admission of pupils with an EHCP in terms of following on from our case example, really, to emphasise that once a school has been named, there is a duty to admit. But can you buy any time in any way? And what are the risks around that you need to consider in terms of any potential legal response by either the local authority or the parent? So in terms of being named in Section I and then admission, it's possible that it may not be necessarily to admit the pupil straight away after having taken legal advice, in terms of you may be able to get further information from the local authority, organise more support and integration in order for there to be a planned admission of the pupil to the school. However, we do need to consider other relevant guidance as well, in terms of the safeguarding obligations and the attendance guidance as well, which, for your information, also is going to be a slight different version from the 19th of August this year. But the pupil does have a right to full-time education. You need to consider what is in the pupil's best interest, and if there is any delay in admission, that needs to be for the shortest time possible, and potentially with the agreement of the parent, the pupil and the local authority. The next slide, please. So we're going to come on to look at something slightly different now in terms of a scenario that schools face where the consultation is about a pupil who is a school refuser. So this can be a really challenging situation. It may be a situation where an EHCP assessment is being made for a pupil that is already on your roll rather than a new pupil. The school needs to be very mindful as well of any safeguarding duties to the pupil once it's named, because they will continue even if the pupil isn't on school site and is refusing to attend. It's also helpful reminding everybody about the local authorities' duties here as well, which under Section 19 of the Education Act 1996 says that each local authority shall make arrangements for the provision of suitable education at school or otherwise than at school for children of compulsory school age who, by reason of illness, exclusion from school or otherwise, may not for any period receive suitable education unless such arrangements are made for them. So it's clear, and the case that's cited there, the Croydon case, that the local authority remains ultimately responsible for making the provision if the school or the other party or any other party, for example, a college, fails to do so. So I think it's important to bear those duties in mind. However, there are other considerations for the school as well. So the next slide, please. So in terms of the Children and Families Act, Section 61 says that special educational provision otherwise than at school, or EOTAS as we most commonly refer to it, can be provided for in an EHCP. It says that a local authority may arrange for special educational provision that it's decided is necessary for a child to be made otherwise than in a school or effectively a college, or a place at which relevant early years education is provided. So that's framed there as discretion, that they may provide it, and essentially that's referring to the local authority's duty in Section 42 of the Children and Families Act, that the local authority must secure the SEN provision set out in the pupil's EHCP that it maintains. So there may be some arguments that a school may wish to consider in relation to a child that's not attending school, as to whether EOTAS is actually the appropriate provision for the local authority to refer to in the EHCP. The next slide, please. And to come on to some recent cases that explain that position for us. Again, these are cases that have happened in the last year or so. The first case in relation to North Somerset Council, the case decided that the test for EOTAS is the power to arrange for special educational provision to be made otherwise than at a school, and that it only arises if a finding is made, so if there's evidence that it would be inappropriate for the provision of that child or for that child to be made in a school. So the test in law for EOTAS is it's framed as being whether in general it would be inappropriate for the provision required for that pupil to be made in a school. And the court said there that it was a general provision, and it's a test in terms of a reference to a school, and rather than the particular school that the parent may be referring to. So it's a general test. And then in the Camden case, the tribunal there decided that sections F and I of a pupil's EHCP can refer to EOTAS. In that particular case, what the EHCP stated was that that pupil will require special educational provision to be delivered somewhere other than in a school, brackets EOTAS. And the upper tribunal decided that EOTAS wasn't a vague expression, and that it meant provision being outside of a school, that there would be no involvement from any school in this case, that the pupil wouldn't be attending a school for the purposes of the EHCP. And so therefore, the EHCP didn't need to name a school in section I, and that EOTAS was sufficient in that particular case, and that the tribunal had no objection in principle to EOTAS being included in section F. So I think those are some relevant and helpful cases in the context of education other than at school that are recent case law developments. The next slide, please. So I'll now hand back to my colleague, Bradley.
Thank you very much. So this is something we're seeing more commonly, and it's mainly where a student's been admitted as an EHCP, and they start presenting with challenging behaviour, and schools are struggling to manage the behaviour. There is a common myth that once a child is admitted, there's nothing they can really do, and the school's unable to effectively utilise its behaviour policies and procedures. A starting point that we'd always consider, and would advise you to from the earliest opportunity, is to consider the behaviour in schools guidance and the suspension and permanent exclusion guidance. These documents really should be used to assist in your approach, and they both have sections. They both have sections regarding pupils with SEND and those with EHCPs. They're sister documents and should be read alongside each other. You also need to consider your Equality Act obligations and the application of reasonable adjustments and what needs to be put in place to best support that student. Reasonable adjustments is it's quite a woolly term. What does that mean in practice for you? Firstly, it's the strategies and interventions that have been recommended regarding that pupil. Are they all in place? Are they effective? Do they need changing? And it's not just a sort of a tick box exercise. Once it's done, it's complete. It's evolving. It's an ongoing role, and just checking for those developing needs. And it's really important that you seek advice from the local authority and other professionals just to input on our multi-agency approach and best support you and best support the pupil. These documents we often see are referred to sort of halfway down the track or towards the end of the track when things are in a really bad place. These documents shouldn't just be used for sanctions purposes, and this, when you are at that stage, it's really difficult to sort of backtrack and get things back on the right way if we can. So when you're sort of at the really early stages and you're noticing behaviours deteriorating, use these documents, use the specific paragraphs, and try and utilise them along with support from colleagues and local authority and other professionals. If there are challenges to suspensions, exclusions, we've often seen that they relate to preventative measures, and that is explicitly referenced in this guidance. So that's another additional reason why it's beneficial to start looking at these from the outset. Next slide, please. So looking at the behaviour in schools guidance in a little bit more detail, the guidance itself obviously includes a lot more information, and this is just a couple of bullet points with the sort of key text regarding behaviour expectations in pupils with SEND. You'll see in the middle there is a couple of lines highlighted in yellow. This is a really important point to flag. So if you have a student who already has an EHCP and you notice a deterioration or there's a escalation in behaviour or additional problems, you should request an emergency review. And if a pupil doesn't have a EHCP, so whether that's not at all or there's one in draft, there's a consultation taking place, you're in communication with parents, it's equally really important to request a statutory assessment, because that may identify additional needs, and you can also consider how well the school is suited more broadly to assist that pupil in his needs. With regards to emergency reviews, if hypothetically we're looking at a situation where the school is looking to take action against the naming in an EHCP, judicial review, by way of example, is a remedy of last resort. And the court would look to see that the school has pursued all avenues before taking any legal action. And if an emergency review procedure has been instigated, that is something the school can be criticised for. So it's something that we really think you should try and consider and adopt as best you can, and involve those other professionals. Take a multi-agency report, again, to best support you to get the right outcome and best support the pupil to make sure they have their needs met in the most appropriate manner. Next slide, please. Still on the behaviour in schools guidance, and I think we're mindful that it's very easy for me and Nicola to sit behind a screen and talk these points to you when you're on the coalface and you're experiencing the sort of day-to-day difficulties of challenging pupils and managing competing objectives. And just because a pupil does have SEND, that's not an automatic assumption that that's a manifestation of their disability. And as Nicola referred to earlier, it's a question on the facts. It's the student, the situation, the incident, what's happened, what's that person's prior history, and what is happening in the background which may be affecting that behaviour. There may be common behaviour traits that are happening which are a manifestation. And if that is the case and you find they're deteriorating, again, push for that multi-agency discussion and consider whether the EHCP does actually remain fit for purpose. Again, I said earlier about the conjunction with your quality obligations. In these circumstances, you may also want to consider your reasonable adjustments and whether these are still fit for purpose and whether these need to be slightly adjusted to best meet needs. Next slide, please. Looking at the suspensions and exclusions guidance, it may appear a little premature to consider this guidance at the start of deteriorated behaviour, but it is important to remember that these types of sanctions are of last resort and should only be sort of really saved for the more serious situations. As part of this, you'll want to consider a wide range of school policies, not just the behaviour. You've got your SEND policy, your equality policies, and there's lots of additional information you may want to take into account. And we're increasingly seeing suspension and exclusion decisions being challenged. And when they are being challenged, the school's actions and the evidence behind those actions and its documented records will really be scrutinised. I'm sure that some of you have unfortunately been through one of the procedures listed at the bottom of that slide, and if you have, they're not nice to go through. They're uncomfortable, and you do feel like you're being tested. And it's really, and that's where the proof is in the pudding with regards to your paperwork. If you've got everything correctly documented, the information you received, your analysis of that information, and your decisions based on that analysis, it can only serve to help you when it comes to, for example, your GDMs or your independent review panels. You really also need to be considering retaining evidence of where you've kept child's needs under review and documenting these reviews with the parent frequently. There are unfortunately things we can't prevent. Parents can choose to take disability discrimination out in the first tier tribunal. They may choose to bring judicial review. They may choose to make complaints. Whilst we all appreciate that they are difficult to manage, I suppose costly, and take up a lot of your time, then that's where good preparation, I think, sorry to keep on with this point, but that's where good preparation really comes in to serve you well and push you on the best possible footing to deal with these types of situations. Next slide, please. So moving on to the Equality Act. So this has been mentioned throughout the seminar this afternoon. And we just wanted to spend a couple of slides just running through this, just so it's clear how this will apply and what you need to consider when dealing with pupils with SEN. So the Equality Act will apply whether a pupil has a EHCP or not, and Section 6 of the Equality Act will sets out the legal definition of disability, which I'll quickly run through. So this definition is whether a person has a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on that person's ability to carry out normal day-to-day activities. Whilst that's quite wordy, it's quite a low threshold. There's no need to have a formal medical diagnosis. Substantial means more than minor or trivial, and for it to be long-term, it has to be 12 months or more. Based on that definition, it can be quite loose, and a lot could fit into that definition. So we do advise a cautious approach. And with that, there is a proactive duty to make reasonable adjustments. The Equality Act does apply to both admission and treatment upon admission, and it is unlawful for a school to discriminate against a pupil either directly or indirectly. Directly is probably a little bit more overt, and that's where a school may discriminate by treating the pupil less favourably as they would treat others. An example of this could be refusing to admit a student with a particular disability or an advanced disability. Indirect discrimination is a little bit more nuanced, and this is where a school will apply a practice or a provision which is discriminatory in relation to that person's relevant protected characteristic. In this case would be disability. A good example of this, which we've seen in the past, is a blanket approach to the enforcement of a behaviour policy, and it may say that no swearing-ins allowed or sanctions will be applied. Excuse me. In the case of you have a student on your roll that has Tourette's and they have an outburst in school, if you apply that blanket policy to that student, you are indirectly discriminated against them because they are unable to help the fact that they're using inappropriate language based on their disability. Next slide, please. Moving on to Section 15 of the Equality Act, and this specifically references conduct relating to discrimination arising out of a disability. This, in very broad terms, is where a school may choose to treat a pupil unfavourably and is unable to show that its actions are a proportionate mean of achieving a legitimate aim. Section 20 also discussed reasonable adjustments. We've discussed these throughout this afternoon seminar, but at a very high level, that's where schools are required to take reasonable steps to avoid the disadvantage somebody is facing as a result of their disability, and this also applies for auxiliary aids. Next slide, please. So whilst this is an independent school case, it does have application to the academy sector and is really a significant case in the sector. I'm mindful that me and Nicola have asked you to do a lot of reading based on this webinar, but if you do get the time, we do strongly recommend that you look at this one because it's an interesting case, it's an interesting tribunal decision, and it's definitely worth reading the background. Again, the caveat is that each case is very fact specific, so that needs to be taken into account when looking at the decision here. But in this case, the pupil presented with very, very bad behavioural issues. They were very significant, and they also had an EHCP. pupil was excluded, and the school suggested that this was lawful because its legitimate aim was the health and safety of its pupils and staff. The parents' position was that the child's disability was not taken into account. The tribunal held against the school, and amongst a number of reasons, the reasons for that was the school did not put into place all the suggested provision. It did not request an emergency review, which I discussed a little bit earlier, and it appeared to treat this student differently than it would other students in those particular circumstances. Again, this really just demonstrates the nuance and particularization of these types of cases and the importance of considering everything we've discussed this afternoon and accurately documenting those analysis and decisions. Can I go on to the next slide, please? This slide is more a reference point for you. This is incredibly helpful guidance. It's technical guidance for schools published by the EHRC, and it provides case studies, practical examples, and it's a really it's a nice, for want of a better word, it's a nice read because it allows you to really break down the reasonable adjustments and the equality considerations, and something to bear in mind when you're making this day-to-day decisions. And we definitely strongly recommend that you consider this when you get the time. Next slide, please. Nicola, I think I'm going back to you.
Thank you, Bradley. That was really helpful explanation there. So yes, our slide here is we've explained the legal overview and given some practical tips and how can we help you in other ways. So and in particular with this particular topic. So we do have a subscription service in terms of compliance toolkits, which some of you will be subscribed to already, which can give some timely and helpful updates on matters such as this. We do provide webinars such as this, and we can also provide school or trust specific ones for you as well. In relation to EHCP consultations, we do have a VWV template response, which we have drafted in order to assist clients in covering the legal test in Section 39 of the Children and Families Act. So that is often very helpful for clients to have in order to structure their response, because they can be very lengthy and it needs to be set out in a logical and legally robust way. So we have a template that we can provide. We can also advise and even draft individual EHCP consultation responses for you, as I've referred to before. We can advise on strategy and drafting correspondence to the local authority, particularly given how we've talked about today, the importance of continuing correspondence is. And we can also advise you on risks and strategy when conducting or considering legal challenges in terms of those routes that we've talked about today. In relation to pupil behaviour and SEND, we can advise on risks and strategies in terms of a particular difficult situation that you may be facing. We can advise on follow-up or preparation for emergency EHCP reviews. We can advise on the regulatory requirements relating to suspensions and exclusions, and also included here are the challenges, the statutory challenges that academies and maintained schools need to comply with, and the relevant guidance if a parent challenges a suspension or an exclusion. And we can also assist with Equality Act and Disability disability discrimination claims too. And finally, we can support on parental complaints regarding to any of these scenarios. And I hope that those pointers are helpful for you in terms of how we're able to assist schools. And please don't hesitate to contact us if that's something that would be helpful for you to get support from us for. One thing that I wanted to add at this stage, which may have been better set out at the beginning, is that this webinar, as you know, is for academies and maintained schools. And I do know that we have some independent school colleagues on our webinar today. So in terms of some of those legal duties that we've been discussing, they are slightly different for independent schools compared to AMS sector schools, and therefore it's just really, if you are an independent school, then a word of caution in terms of the applicability of the law that we've been discussing today, because there are some differences, important differences here. So that's a caveat really at the end in terms of those people attending from independent schools. The next slide, please. I think we have just a few minutes left at the end of our build slot. We have gone over the hour, but we have a few minutes if people would like to stay for some questions and some answers. Bradley, I think we've both been monitoring the books. Would you be able to pick out any questions of interest, please?
Yeah, of course. So apologies in advance if I missed your question. We have had a significant couple come through. I'm just looking at general themes and how to, I suppose, couch a couple of questions together. So here's one. Nicola, would you be able to help with this one, please? What do you do if the school is not provided with sufficient information to respond properly?
Yes, so in terms of the school's position at the outset, it's really important. I think it's a good chance to emphasise the importance of the school ensuring that they have all of the sufficient information that they require in order to make a response under Section 39 in terms of any relevant assessments or reports that they believe are in place for the pupil, and that our advice can be in situations would tend to be that if a school isn't satisfied that it has all of the relevant information that it requires from the local authority in order to prepare the consultation response, then they politely go back to the local authority, ask them for everything, and state clearly that they'll be working on the basis that until they have received all of the relevant information, then they will not take the 15 days for the response time to run. So that's at the outset. And then, as we know, these processes can be protracted. So the other relevant piece here is do be proactive in asking for any other updated assessments or reports as time goes on, because it may well change your position and there may be additional evidence that you want to refer to.
That's brilliant. Was there any questions you may have seen? I think I've just seen another one, which I think I'll be able to pick up and give you the opportunity to read through the questions then, Nicola. The question is, what happens where a child's behaviour is difficult to manage and there isn't parental support for the school? Unfortunately, a sad situation that we're seeing more of. Parental expectation and can be difficult to manage, particularly when there's lots of expectation in the light of financial pressures and competing objectives. Like I went through earlier, I think the starting point should be to look at that guidance and at the earliest stage possible, really push to look at what interventions are in place. Are they still appropriate? And how can the school, working with other relevant agencies, best address the challenging behaviour? And a key part of that, where there's an EHCP, is an emergency review, because if we look into challenge decisions later down the line, the participation of an emergency review, I think, will be key to show the school is demonstrating a sensible and proportionate approach. Just seen another one, if you're happy to pick up,
Yes.
please, Nicola.
Thank you, Bradley. You're being very efficient in looking through what's in the Q&A. Somebody asked, where can we post the questions? It's in the Q&A box, which should be somewhere on the toolbar of your Zoom meeting.
Again,
So yeah, please do go ahead with the other one.
Yeah, of course. I think it's it's a bit of it depends, which a question which can be a typical lawyer answer. Can it be worth the risk of could it be worth taking the risk not to admit when you're named?
Thank you. That is something that I would the answer I would heavily caveat, actually. Bradley, I referred to different types of schools and being on our webinar, and different legal duties that apply to different types of schools. So I think, first of all, we need to consider what type of school are we in terms of the duty to admit. I think also in relation to the risks that I outlined earlier, the facts and circumstances of individual cases are going to be highly relevant here, because there are significant risks that we've outlined. So I think that requires a more nuanced answer, actually.
Okay. Just checking, have you had a chance to check the Q&A if there's anything else that's immediately springing out in terms of themes?
We've got lots of questions here, which I'm afraid we're not going to be able to answer all of them. There's just one more that I wanted to pick up, and I'm happy to deal with it, Bradley, and that's in relation to, we've had a few questions around the time limit, so the 15-day consultation period, and what happens if the consultation arrives just before the school break. And unfortunately, in the Code of Practice, it refers to 15 days, and therefore it's not school days. So if a consultation arrives during a holiday period, unfortunately, that is challenging for a school, because the Code of Practice requires a response within those 15 days. And in terms of those being working or calendar days, then we would work on the basis of them being calendar days. I do think that somebody spotted that in the PowerPoint it referenced working days. So it's 15 calendar days. So we'll get that corrected. And in terms of school holidays, I'm afraid that the school still needs to reply in time. Was there any final question that you'd seen, Bradley?
Just quickly running through. I think there's just one. I'm mindful that we have got lots of questions, and just a plea to everybody on the webinar: if there is anything sort of active matters or cases you're dealing with in school, if we just move to the next slide, please. Please do get in contact with Nicola or I, because we really will be pleased to assist. And I'm just mindful that a lot of the answers to questions will require a lot of nuance. There's not a black or white straightforward answer, unfortunately. But
Thank you, Bradley. Well, we are virtually at 4 o'clock anyway, and have certainly used more than the hour. So there's a short poll here that we'd be very grateful for you to complete before you do leave our webinar. And all it remains for me to do is, on behalf of Bradley and myself, to thank you very much for attending, and we hope that you found this useful. Thank you, and have a good rest of the afternoon.
Thanks all.